Hours after my father's funeral, Charles Whitman, the attorney holding Dad's will, read the line giving our farmhouse, workshop, and acreage to my older sister Brooke. Then Brooke slid a move-out notice across the table and said an estate sale crew would empty the house within 72 hours. I was Natalie Carter, 44, an emergency department charge nurse, who spent 6 years managing Dad's care and midnight crises. Yet, this will was 12 years old, signed when Dad and I were barely speaking. In his final year, he had promised me the house would never be taken from me. What scared me most was Brooke's rush to clear his books before anyone had divided his belongings. I refused to sign the paper accepting the distribution. Dad's last text had told me to find the blue book because he had fixed what should have been fixed years ago. Brooke warned that once she became executor, my access to the study would end. I had less than 72 hours before the shelves were cleared. And Brooke seemed determined to make everyone count. Back at Dad's farmhouse after the will reading, I asked my older sister for one thing: delay the estate sale until we could review his recent papers together. I still believed some part of this could be settled without turning grief into a war. Brooke stood in the entry hall with Dad's keys looped around one finger and said the will had already settled what mattered. She reminded me that Dad had signed it freely 12 years earlier, then added that I had chosen to come home and care for him. 6 years of hospital runs, medication charts, repairs, and nights beside his bed became a choice I had made for myself. I told her I was not asking for more money. I was asking for time. Brooke said time was exactly what the estate did not have. She had already spoken to an estate sale company, and a developer interested in the back acreage wanted a clean path forward. While I had been choosing flowers for Dad's casket, Brooke had been planning what happened to his property afterward. I asked to collect only things that were clearly mine. Brooke agreed, but she followed me into Dad's study and stayed close enough that I heard the keys click against her palm. Bright estate sale stickers were already on the lamp, filing cabinet, drafting stool, and brass clock Dad had wound every Sunday. When I opened the lower desk drawer for a folder containing my nursing records and old tax papers, Brooke stopped me. Estate documents stayed in the house, she said. I told her the folder was mine. She told me to prove it before touching it. The humiliation steadied me. In the emergency department, chaos gets people hurt when everyone reacts before checking facts. So I stopped arguing about fairness and started noticing details. I took out my phone to find a photograph of Dad's final medication list. While scrolling, I passed his last text to me: find the blue book before you sign anything. I fixed what I should have fixed years ago. After his death, I had read those words until they felt meaningless. I had assumed pain medication and exhaustion had tangled his thoughts. Standing in the study with Brooke guarding drawers and sale stickers spreading across Dad's belongings, the message sounded different, specific: blue book. Before you sign anything, fixed. Dad owned plenty of blue books, but one memory surfaced sharply. The faded birding guide we had carried on weekend drives when I was a girl, with a loose lining inside its back cover. I could not remember seeing it recently. I asked Brooke whether any books had already been packed. Her eyes moved toward the shelves before she answered. She said the sale crew had begun sorting, but nothing important had left the property. I could not know whether her pause meant anything, and fear was not proof. Instead of accusing her, I photographed each wall and shelf. Brooke asked if I was documenting my childhood now. I said maybe I was. I did not tell her that Dad's message had become the first thing in the house she did not control. The next morning, I returned to Charles Whitman's office. Charles, the attorney who had read Dad's formal will, told me no later formal will existed in his file and reminded me that he was handling the estate process, not representing me. I asked when Brooke's will had been signed. Hearing the date aloud tightened something in my chest. Dad had signed it years before I returned to Texas, when he and I could go months without speaking. I asked whether his promises during his final year mattered. Charles said spoken promises were not a substitute for a valid testamentary document. Then he mentioned that Brooke had asked him to prepare the executor paperwork as quickly as possible. That changed the problem. Brooke did not merely have a favorable will. She had a timetable. Once the court gave her formal authority, she could gain greater control over estate access and decisions. I asked Charles whether I could stop the cleanout. He said I needed my own lawyer if I intended to challenge the administration. I left with the old will still controlling every practical fact and one unexplained message from Dad sitting on my phone like a locked door. By noon, I was in the office of Maya Singh, a 39-year-old local probate litigator recommended by a nurse I trusted. Maya was calm and precise, the kind of person who did not confuse urgency with certainty. I showed her the old will, Brooke's move-out demand, my photographs, and Dad's final text. Maya read the message twice, then asked whether I had the blue book. I said no. She asked whether I knew Brooke had it. Again, no. The questions exposed how little I truly possessed. I had memory, grief, and suspicion. None of them became evidence because I believed them. Maya told me not to accuse Brooke of hiding a will when I did not know another will existed. What we could do was preserve material before it disappeared. A written preservation demand could put Brooke and the estate sale company on notice that books, handwritten papers, and estate records might matter to a probate dispute. I asked how quickly she could send it. Maya slid a retainer agreement toward me. The amount was almost everything in the emergency account. Dad once made me promise not to touch unless something had gone truly wrong. Brooke had the house, the keys, the formal will, and the momentum. To slow her down, I had to spend the money that made me feel safe enough to survive one broken car or one unpaid week. My old instinct told me to conserve, endure, and avoid making family conflict worse. Then I pictured the stickers on Dad's shelves. I signed. Maya sent the preservation letter that afternoon to Brooke's attorney and the estate sale company. Driving toward the farmhouse, I understood there was no longer any way to pretend Brooke and I were simply grieving badly. We were now on opposite sides of a legal record. Halfway there, Brooke called. She asked whether I was really going to freeze Dad's estate over one text message. I said I was trying to keep relevant belongings from disappearing before I understood what Dad meant. Brooke said that since I had involved lawyers, there was no reason to give me extra time in the house. The book removal would begin the following morning, earlier than originally planned. I asked her to leave the study untouched until our lawyers spoke. She refused. By the time I reached the farmhouse, 2 estate sale workers were already carrying flattened boxes through the front door. Brooke stood on the porch, holding a clipboard. I told her Maya's preservation notice had been sent. She said her attorney would answer through proper channels. Behind her, one worker came out of Dad's study carrying a box filled with books. I moved toward the doorway, but Brooke stepped in front of me. Over her shoulder, I could see that one section of the study shelves had already been cleared. I did not know whether the blue birding guide had been there. I did not know whether Dad had hidden anything inside it. I only knew his final message had told me to find it before signing anything, and the person with the old will was speeding up the removal before I could obtain a court order. My preservation letter had started the fight. It had not stopped the boxes from moving. My preservation letter had started the fight. It had not stopped the boxes from moving. By the next morning, it had given Brooke a story to tell about me. Aunt Linda, my father's younger sister, called before I finished coffee and asked why I was holding up the estate over a book. Brooke had reminded everyone that Dad helped pay for my nursing school and that I had lived in his house during his illness. In the version spreading through the family, I had already received my share and was punishing my older sister because I disliked the will. I told Aunt Linda the document was 12 years old, and Dad's final text told me to find something before signing anything. She asked whether I had another will. I said no. She asked whether I had proof Brooke had done anything wrong. I had to say no again. That hurt because Aunt Linda had thanked me at the funeral for caring for Dad. Now even she sounded embarrassed by me. Maya had told me to preserve evidence, not arguments. An hour later, a cousin texted me a photograph taken from the county road. Brooke stood near the rear acreage beside a black sport utility vehicle bearing the logo of the developer she had mentioned. The picture did not prove a sale, but it proved someone was already walking Dad's land while his books were still being boxed. I searched my phone because I needed to know which blue book Dad meant. Then I found a photograph from 3 summers earlier. Dad was sitting at the kitchen table, holding the faded birding guide we had carried on weekend drives when I was a girl. The bottom corner was pale where his thumb always rested. I remembered the loose lining inside the back cover and how he sometimes tucked receipts and folded notes there. Suddenly, his last message had shape. The estate sale company had posted a public catalog online. I checked every photograph twice. No birding guide appeared. I compared the catalog with the pictures I had taken in Dad's study. The guide was missing from both. That did not prove Brooke had removed it. A worker might have boxed it, or Dad might have moved it before he died. I needed the inventory made before the shelves were disturbed. The company name on Brooke's clean-out notice led me to Mason Reed, the estate sale photographer and appraiser she had hired. When I called, Mason said Brooke was his client and he did not involve himself in inheritance disputes. I told him I only wanted to know whether his original photographs still existed. He said they did, but he would not release client material. From the hospital parking garage, I called Maya. She sent Mason a neutral preservation demand requiring him not to delete photographs, inventory notes, emails, or metadata while the probate dispute was active. 2 days later, Mason agreed to let us identify items in his original image set at Maya's office. He was a broad-shouldered man in his early 50s who kept turning his wedding ring while Maya explained that no one was asking him to take sides. Mason said Brooke still owed part of his invoice, and he feared being blamed if property went missing. I understood why he had stayed quiet. We viewed his photographs in order. In an early frame, my breath stopped. The faded blue birding guide stood crooked between a field atlas and an old tractor manual. I knew the worn corner and the pale strip along the spine. Mason opened the file information in front of me. The image had been taken after Dad died during the first inventory pass, before the estate sale crew began removing books. For the first time, I had a fact Brooke could not erase by calling me greedy. In a later photograph of the same shelf, the guide was gone. It did not appear in Mason's sale list. He opened his handwritten work notes. Beside one inventory number was a short line. Blue Book and family papers removed by client. Mason explained that he noted anything a client pulled after photography so his count stayed accurate. I asked who client meant on this job. He looked at Maya before answering, Brooke. The note did not tell me what had been inside the book or prove Brooke knew what Dad's text meant, but it established 3 things. The guide survived Dad's death, it entered the estate inventory, and Brooke personally removed it from the normal sale path. I wanted to drive to the farmhouse and demand it. Maya stopped me. Confronting Brooke would only tell her which object mattered most. We needed Mason's files preserved and court protection broad enough to cover books and handwritten papers. One reckless accusation could destroy the trail I had finally found. Before Maya filed anything, Brooke's attorney proposed mediation. I agreed because part of me still wanted to end the dispute without turning Dad's last months into exhibits. Brooke arrived with her lawyer and a folder already prepared. The offer gave me enough cash to repay Maya's retainer, cover moving expenses, and rent another place for several months. In exchange, I had to withdraw any challenge to the old will, waive further claims against the estate, and leave the farmhouse. For a moment, the money felt like oxygen. My emergency reserve was almost gone. Then I read the waiver again. If I accepted, I would never learn why Dad told me to find the blue book before signing anything. I asked Brooke where the birding guide was. Her lawyer said mediation was not an evidence interview. Brooke said hundreds of objects had been moved, and she was not going to inventory the house from memory. I could not know what she was thinking. I knew only what Mason's files showed. The guide was photographed after Dad's death, and Brooke removed it. The settlement required me to stop asking why. I pushed the folder back across the table. The settlement collapsed. Maya then sought a narrow temporary preservation order covering books, handwritten papers, and estate records connected to Dad's final instructions. Brooke's side called it harassment, but Mason's photograph and work note gave us a specific trail. The court temporarily barred disposal or destruction of those disputed categories while access was sorted out. It was not ownership, and it did not let me search the house. Still, for the first time since the will reading, Brooke could not legally make every important object disappear simply by moving faster. That victory cost me the last illusion that the family would stay neutral. Aunt Linda stopped answering. A cousin removed me from the family group message after someone accused me of freezing Dad's estate over a childhood keepsake. At work, I sat alone in my car during breaks because I was too tired to explain why my phone kept filling with messages from people who had already decided who I was. Near the end of the day, Mason found one more preserved record. He had an email from Brooke ordering him to exclude a box labeled family papers from the public sale inventory. Maya read the wording to me over the phone. The message did not say what was inside, and it did not mention a will. But the pattern was no longer random. Brooke had removed the blue guide, and she had separately ordered family papers kept outside the normal sale list. The preservation order meant those materials could not legally be destroyed now. It did not tell me where they were. That evening, I stood alone in Dad's dark kitchen and understood how much the fight had changed. I had begun with a strange final text and no proof. Now I knew Brooke had personally pulled the exact kind of object Dad told me to find and isolated other family papers before I ever challenged the will. I was no longer asking whether my father had left something behind. I was facing the possibility that my sister had already moved the truth somewhere I could not reach. I was facing the possibility that my sister had already moved the truth somewhere I could not reach. The preservation order stopped Brooke from destroying covered materials, but it did not magically tell me where she had put them. The next morning, Maya Singh, my probate lawyer, asked me to work backward from facts we could prove. Mason Reed's photographs showed the blue birding guide on Dad's study shelf after his death. His work note showed Brooke removed it. His later photographs showed boxes being loaded for storage. Somewhere between those images was the path I needed. I sat at Maya's conference table with printed photographs spread in front of me and forced myself to look at them the way I reviewed an emergency chart after a bad shift. Sequence first, conclusions later. One box in Mason's loading photographs caught my attention because a torn brown tax ledger protruded from the top. I knew that ledger. Dad had kept receipts inside it for years, and I had seen the same ragged corner in an earlier picture of the study, less than 2 feet from the blue guide. In the loading photograph, the ledger sat inside a box marked damaged manuals. I asked Mason, who joined us by video, whether that box had gone to the sale warehouse. He checked his records and said no. The client had directed several boxes of papers and books to an off-site storage facility. Maya asked whether his records identified the facility. Mason searched his invoices and found a delivery notation with the storage company's name. That was enough for Maya to request preservation of the relevant access records and to ask Brooke's attorney where the disputed materials were being kept. Brooke's response came through counsel. Estate property had been moved among several locations for safekeeping, and she denied knowing the location of any individual book. I could not prove that statement was false. But the storage company's access log, produced after Maya's request, showed Brooke had entered the unit by herself after our preservation letter had been sent. I wanted to say Brooke had gone there to hide the book, but Maya stopped me from turning suspicion into fact. Brooke could have entered for many reasons. What mattered was that a photographed box now led to a specific unit. Brooke's attorney opposed inspection, arguing that one cryptic text did not justify searching private estate papers. Maya answered with our actual trail. Dad's message, Mason's time-stamped photograph, his note that Brooke removed the guide, and the loading image linking nearby materials to storage. The judge allowed a narrow supervised inspection. If the book was not there, I had no idea where to look next. 2 mornings later, I met Maya at the storage facility. Brooke arrived with her attorney. A neutral lawyer appointed to supervise the inspection stood beside a folding table while an employee rolled up the metal door. The air inside smelled like cardboard, dust, and hot plywood. Dad's life had been reduced to stacked boxes with black marker across the sides. Brooke watched me from several feet away. I did not ask her anything. The rules were simple. I could identify relevant items, but nothing was to be removed, opened beyond the approved scope, or handled without the supervisor observing it. We found the box marked damaged manuals near the back wall under 2 plastic bins. My hands began to shake before the supervisor cut the tape. The torn tax ledger was on top, exactly as Mason's photograph had shown. Beneath it were appliance manuals, old hunting magazines, 3 loose folders, and a thick field atlas. Then I saw a faded strip of blue cloth along the bottom edge. I knew the book before I touched it. The birding guide looked smaller than I remembered, its corners rubbed almost white. Seeing it pulled me back to childhood mornings, when Dad woke me before sunrise for birding drives. I had spent years believing those mornings belonged to a father and daughter who no longer existed. The supervising lawyer photographed the book where it lay. Only after she finished did I lift it onto the table. I opened the back cover. The loose lining was still there. Something white showed beneath it. I stopped breathing. Maya told me not to pull it out. The supervisor photographed the cover, the lining, the exposed corner of paper, and my hands away from it. Then she used gloves to ease out a folded sheet. Every movement was documented. No one in that room would later be able to say I had slipped something into the book when no one was watching. The page was covered entirely in handwriting I recognized as Dad's. The sharp capital T in Thomas, the forward-leaning R, the uneven pressure from his arthritic hand. Recognition was not proof, but when the supervisor unfolded the page enough for us to read the first lines, my knees weakened. Dad had written that he was revoking all prior wills and testamentary instructions. The room went silent. I read the date twice. It was from his final week. Then I read what came next. He left the farmhouse and workshop to me. He directed that the development acreage be sold by a neutral representative rather than by either daughter. After expenses, the net proceeds were to be divided equally between Brooke and me. He wrote that circumstances had changed and that he no longer wanted an old period of estrangement to decide what happened after his death. Dad had not punished Brooke. He still gave her a substantial inheritance. If I tried to use her conduct to claim everything, I would be treating his estate as a prize instead of an instruction. Brooke's attorney asked the supervisor to note that the page had no conventional witness signatures. He did not touch it. He did not need to. The handwritten sheet looked painfully informal beside the polished Will Charles Whitman had read after the funeral. For one terrible second, I wondered if the document we had spent all this time finding might be worthless. Maya told me we were not going to decide validity in a storage unit. We would preserve the document, establish chain of custody, and determine what evidence existed to authenticate it. I looked at Brooke. She was staring at the page, but I could not know whether she was surprised, afraid, or simply calculating. I stopped trying to read her face. I had something better now, a document that could be tested. The handwritten will became the center of everything. Maya arranged for the original to enter the probate process under supervision. Our next problem was proving the writing belonged to Dad without relying on me. I thought of Helen Brooks, Dad's retired business bookkeeper, who had seen his handwriting on estimates, checks, and ledgers for decades. When I called, Helen was quiet for so long I thought the call had dropped. She finally said she did not want to be the person who destroyed what was left of our family. I told her I was not asking her to choose between Brooke and me. I was asking whether she could identify Dad's handwriting if shown a document through proper channels. She said she could, but she wanted to see comparison material she knew had been created years earlier. Helen still had archived copies of business ledgers. Dad had written in by hand. Maya also obtained examples from records already tied to the estate. Helen reviewed the handwriting and told Maya, in my presence, that the writing on the hidden page matched the same habits she had seen for years. Her certainty did not magically make the document valid, but it gave us one independent witness with no financial interest in who inherited the land. Maya wanted another source. I remembered Daniel Cho, the credit union loan officer who had handled Dad's equipment loans for years. I knew Daniel only from accompanying Dad to the credit union once after his hand surgery. Maya contacted him through formal channels rather than having me show up with the disputed document. Daniel located archived loan papers bearing Dad's undisputed handwriting and signature from years before his death. After comparing them with a copy of the handwritten will, he was willing to testify that the writing was consistent with Thomas Carter's. Two independent people and ordinary records created long before the dispute meant the evidence was beginning to stand without me. That did not make it painless. Every piece of proof widened the circle of people who now knew how divided our family had become. Helen had to open old business records. Daniel had to pull archived loan documents. Maya warned me that Brooke's attorney would attack the chain of custody, Dad's mental condition, my access to his papers, and every reason anyone might have to favor me. I told her to file the later will anyway. She did. At the same time, Maya asked the court to stop any transfer of the development acreage until the competing documents could be addressed. The developer transaction Brooke had been pushing did not close. For the first time since Dad's funeral, something Brooke wanted badly had been forced to wait. The victory lasted less than a day. Brooke formally challenged the handwritten will. Through her attorney, she alleged that Dad lacked capacity when it was written and that I had exerted undue influence over him during his illness. She also suggested the document could have been fabricated or planted because I had lived in the house, handled Dad's paperwork, and had access to his personal belongings for years. I read the filing twice in Maya's office. My name looked different inside an accusation. I was not Dad's daughter there. I was a caregiver with opportunity. The accusation borrowed facts from my real life. I had managed Dad's medications, appointments, and discharge folders. I had argued when he ignored medical instructions. Caregiving created an intimacy that could be made to look like control once context was stripped away. Then Brooke produced a home security clip. I had forgotten Dad still had a camera covering the hallway outside his bedroom. The video showed me entering with a folder under my arm during his final month. A few minutes later, the sound captured raised voices. The clip did not clearly record every word, but it showed me pointing toward the folder while Dad sat on the edge of his bed. At one point, I said, You cannot keep refusing this and expect me to clean up the consequences. Watching it made my face burn. I remembered the day only after seeing the clip. Dad had been refusing his discharge instructions. The folder held medication changes, fall precautions, and a follow-up schedule. None of that was visible in an image of a daughter standing over a sick father with paperwork. Brooke's filing gave the clip a different meaning. According to her argument, it showed pressure over documents during the exact period when Dad supposedly changed his estate plan. Maya asked whether I had records proving what was in the folder. I said I might. The hospital discharge paperwork should have dates, and I had probably scanned some pages into the binder I kept for Dad's care. But even if I proved that particular argument had been about medicine, Brooke's larger attack remained. She was saying Dad was weak, dependent on me, and vulnerable to influence. I looked again at the date on the handwritten will. Then I looked at my work calendar. Something bothered me. I had been scheduled for several long shifts during Dad's final week. As charge nurse, my hospital badge records and staffing logs would show exactly when I entered and left the building. If I had been at work when Dad wrote the document, that would not prove he was mentally capable, and it would not prove no one else influenced him. But it could answer one accusation, that I had sat beside him and dictated the will he hid in the blue book. I told Maya I wanted to reconstruct that entire day, hour by hour. She warned me that once we started, we had to follow the evidence even if it hurt us. I said that was the only kind of evidence I wanted. Before I left her office, another message from Brooke's lawyer arrived. They intended to use the security footage, Dad's medical decline, and my caregiving role to ask the court to reject the handwritten will and restore the older document as the controlling plan. If they succeeded, Brooke would regain the path to the house, the workshop, and the acreage, and I would have spent nearly everything I had to prove nothing. For the first time since finding the blue book, I understood that evidence could save me or bury me. I had found the document that might overturn Brooke's inheritance. Now I had to prove I had not created it. I had found the document that might overturn Brooke's inheritance. Now I had to prove I had not created it. The first thing I did was stop trusting memory. Dad's final week had blurred into hospital shifts, medication schedules, and sleepless drives home. Maya Singh, my probate lawyer, told me to rebuild the date on the handwritten will from records no one in the family could control. I opened the hospital scheduling system and pulled my assigned shifts. The date on Dad's handwritten will fell on one of my longest days. I had clocked in before sunrise and remained charge nurse in the emergency department until after dark. My badge entries and staffing logs fixed me inside the hospital throughout the hours Brooke's filing implied. I had been sitting beside Dad telling him what to write. The proof should have relieved me. Instead, I stared at the timestamps and felt sick. Dad had written something important enough to hide inside our old birding guide, and I had been miles away under fluorescent lights deciding which patient got the next available bed. The records proved that on one of Dad's last clear days, I had not been there. Maya would not let me turn guilt into a legal conclusion. My absence weakened Brooke's claim that I dictated the document, but it did not establish Dad's capacity. She asked what medical care he was receiving that day. I told her hospice had been visiting the house during his final week. That led us to Cara Lopez, the hospice nurse whose name I recognized from Dad's care binder. I remembered Cara as the nurse who spoke to Dad directly even when I was standing beside him, never treating illness as if it erased his right to answer for himself. We could not simply ask Cara to tell us whatever she remembered. Dad's medical records had to be obtained through proper legal process. Maya requested the relevant hospice chart for the probate dispute. Brooke's attorney had built a simple picture: sick father, caregiving daughter, hidden handwritten will. If the chart showed confusion that day, my work records might not save anything. When the records arrived, Maya called me to her office. Cara's visit note was written the same day as the hidden will. Dad had been alert. He had correctly identified the day, his location, and the people involved in his care. He had discussed medication choices and refused one change because he wanted to remain awake. Most important, Cara recorded that he asked for privacy because he wanted to write. I read that sentence 3 times. Maya later arranged for Cara to give sworn testimony. Cara said she remembered Dad because he insisted on doing as much for himself as he could. She could not say what he wrote because she never read the paper. What she could say was that when she returned after giving him privacy, she saw him close an old blue book over folded paper. She had no reason then to think the detail mattered. To her, it had been an ordinary moment in a patient's final week. To me, it connected the most painful gaps. Dad had been alone. I had been at work. He had asked to stay clear-headed. He had written privately, and a neutral nurse had seen folded paper with a blue book before anyone knew there would be an inheritance fight. Brooke's attorney attacked the chart through written objections, arguing that being alert during a hospice visit did not prove legal capacity to make a will. Maya agreed that one note did not decide the case. She built layers instead. My hospital records established my absence. Kara's records established Dad's condition and independent writing. Helen Brooks and Daniel Cho supported the handwriting. Mason Reed's photographs established where the book had been after Dad's death. Each fact answered one attack while exposing the next. Brooks' next argument frightened me because it looked obvious. The older will was professionally drafted, formally executed, and stored in an attorney's file. Dad's later document was one handwritten sheet with no conventional witness signatures. Brooks' lawyer described it as a family note dressed up after death as a will. Even knowing what I had read, I understood why that image could be powerful. Maya made me sit down before she explained the legal point. The handwritten page did bear Dad's signature, but the real issue was not whether it resembled the older will. The issue was what Texas law required for a will written wholly in the testator's own handwriting. If the material provisions were entirely in Dad's handwriting and the document was properly proved, the absence of the usual witness signatures did not automatically destroy it. For several seconds, I said nothing. All this time, I had been measuring Dad's last document against the polished one in Charles Whitman's office. Brooke had done the same in every argument. Formal paper against private paper, witnesses against no witnesses, lawyer's file against an old birding guide. But if the law treated a wholly handwritten will differently, then the very thing that made Dad's page look informal could be the reason it survived. That was the twist I had not understood when we found it. The document still had to be proved. Maya warned me that Brooke could challenge handwriting, capacity, intent, revocation language, and the circumstances surrounding discovery. But the fight was no longer about whether Dad had copied the ceremony of his older will. It was about whether the handwritten document was truly his final testamentary act. Helen Brooks came to Maya's office with business records she had kept from years of bookkeeping for Dad. Helen had resisted being drawn into the case because she feared becoming the person our family blamed afterward. She placed an old ledger beside a copy of the handwritten will and pointed out the way Dad formed capital letters, the uneven spacing that worsened when his hand hurt, and the backward hook he often made at the end of certain words. She simply said the writing was Thomas Carter's as she had known it for decades. Daniel Cho, the credit union loan officer who had handled Dad's equipment financing, reached the same conclusion from a different source. His archived loan files had been created years before anyone had reason to manufacture evidence for me. He compared those records with the hidden will and was prepared to testify that the writing and signature were consistent with Dad's known hand. For the first time, the handwritten page did not depend on my recognition of it. That shift gave me enough confidence to think we might survive Brooke's challenge. Then Mason called Maya with something new. Mason had been reviewing records covered by the preservation demand because he did not want to be accused of withholding anything. Buried in his email thread with Brooke was a message sent during the cleanout. Maya asked him to forward the original with its metadata intact. When it arrived, she printed a copy for me, but kept the electronic original preserved. The instruction was short. Brooke had told Mason to remove the old Bluebird guide and any loose handwritten papers from the sale inventory and place them with materials she would review personally. I looked at the timestamp. It had been sent after Dad died. It had also been sent before I told Brooke what Dad's final text said. Anger hit so hard I had to stand. I wanted to call Brooke and demand to know how she knew the blue guide mattered. Maya told me not to. The email proved Brooke identified the book and handwritten papers before I disclosed Dad's message. It did not prove what she knew was inside. If I called her, I would give her a chance to build an explanation before she had to answer under formal questioning. I sat back down. That restraint cost more than any legal bill. Part of me still wanted a private confession that would make the evidence unnecessary. I wanted Brooke to say there had been some misunderstanding, but every time I chased family reassurance, she gained time, so I let the email speak before I did. Maya used Mason's message with the other preservation evidence to challenge Brooke's continued control over the estate. Brooke's attorney argued that she had merely separated personal family materials from items intended for public sale. On its own, that explanation was possible. But the court now had more than the email. It had Dad's text directing me to the blue book, Mason's photographs showing the guide in the post-death inventory, his note documenting Brooke's removal, the supervised recovery of the handwritten will from inside that guide, and the email showing Brooke specifically ordered the guide and handwritten papers pulled before I disclosed the message. I did not need to claim I knew why Brooke had done it. The sequence was enough to make her control of disputed property look dangerous. The hearing on estate administration was smaller than the final will contest, but it was the first time Brooke and I sat under rules neither of us controlled. I testified only about facts I personally knew. Dad's text, when I received it, when I showed it to Maya, what I saw during the supervised storage inspection, and my work records. Mason testified about his photographs, notes, and email. Maya was not asking the court to decide the final will that day. She asked only that disputed transactions and evidence be protected until that decision could be made. Brooke's side warned that delay could cost the estate the developer's offer. That was true. The buyer wanted certainty, and the offer on the acreage had a deadline. Brooke's attorney argued that removing her practical control would reduce value for both daughters. For one terrible moment, I saw the choice clearly. If I pushed forward, the developer could walk away. Even if Dad's later will won, Brooke and I might both inherit less. Legal fees would keep growing. There was no version of this fight where truth arrived without a bill attached. During a recess, Maya asked whether I still wanted her to seek neutral administration over the disputed transactions. I thought about Dad's instruction that the acreage be sold by a neutral representative. Then I thought about accepting a higher price obtained through a process he had specifically tried to prevent. I told her to continue. The court suspended Brooke's authority over the disputed property transactions while the competing wills were pending and placed essential administration in neutral hands. Brooke did not lose every connection to the estate, and the final validity question remained open, but she could no longer race the land toward closing while we fought over which will controlled it. Outside the courtroom, Maya told me the developer might let its offer expire rather than wait. The news clarified the price I had chosen. I was fighting to preserve Dad's right to decide what happened to what he owned. Brooke passed me in the hallway without speaking. I did not know what she felt. I knew what had changed. After the funeral, she had possessed the old will, the keys, the house, the sales schedule, and the path to the developer. Now the books were protected. The hidden will was before the court, the land transaction was frozen, and a neutral administrator stood between Brooke and the estate decisions that mattered most. But the victory was temporary. Maya reminded me that we had not won the will contest. Brooke could still argue that Dad lacked testamentary intent, that the document was not meant to operate as a final will, or that our evidence did not overcome the older formal instrument. We had answered the accusation that I sat beside him and dictated it. We had answered much of the capacity attack. We had built independent proof of handwriting and chain of custody. We had even shown that Brooke isolated the blue guide before I revealed Dad's text. None of that let Maya promise what the judge would decide. The final evidentiary hearing was set. Both wills would be placed before the court. Helen, Daniel, Cara, Mason, and I could all be questioned. Brooke would have the chance to attack every link we had built. If Dad's handwritten will failed, the old will would return to the center of the estate, and the temporary protections I had fought for could become little more than an expensive delay. That night, I sat at Dad's kitchen table with a copy of the handwritten page beside the old birding guide. I did not touch the original. That was preserved through the case. On the copy, Dad's words looked almost painfully ordinary, written in the same hand that had labeled tool drawers and scribbled grocery reminders. The older will had looked powerful because it came from a law office. This one looked vulnerable because it came from him. I finally understood that the final battle was not going to be about which document looked more official. It was going to be about which document the law believed was truly my father's last word. It was going to be about which document the law believed was truly my father's last word. At the final evidentiary hearing, I learned how strange it felt to hear a life reconstructed one exhibit at a time. Maya Singh, my probate lawyer, began with what could be traced. Dad's final text was introduced from my phone records and cloud backup. I testified that I received it before I knew another will existed and did not understand the phrase about the blue book until Charles Whitman read the older will. Then Mason Reed, The estate sale photographer Brooke had hired explained his time-stamped photographs. His first inventory showed the faded blue birding guide on Dad's shelf after his death. His work note recorded that Brooke, his client, removed it. His later records linked nearby materials to the storage load where the guide was eventually recovered. When I described the supervised inspection, I kept my answers narrow. I told the judge who opened the box when the supervising lawyer photographed the guide and how the folded page was documented before anyone removed it from the loose lining. I did not say Brooke knew a will was inside. I could not know that. I did not say Dad hid it because he feared her. I had no statement from him saying so. For months, Brooke's side had benefited whenever this sounded like two angry daughters telling different stories. The moment I stopped trying to explain her motives, the evidence became harder to blur. Helen Brooks, Dad's retired bookkeeper, testified from decades of ledgers, checks, invoices, and estimates. Daniel Cho, the credit union loan officer who had handled Dad's equipment loans, testified from archived records created years before the inheritance dispute. Both identified the handwriting as Dad's. Cara Lopez, his hospice nurse, testified from her chart that he was alert, oriented, making his own care decisions, and asking for privacy to write on the date shown on the handwritten will. My hospital badge and staffing records placed me at work during those hours. The pieces did not ask the court to trust my memory alone. Brooke's attorney emphasized that Dad was dying, that I managed his medications and paperwork, and that I benefited from the later document. He played the hallway security clip of me carrying a folder toward Dad's bedroom and raising my voice. Seeing it again still hurt. Maya introduced the discharge materials tied to that day, and I explained that the argument was about Dad refusing medical instructions. More important, the handwritten will was dated to another day, when my work records put me inside the emergency department. Then the old formal will went before the judge. It looked clean, typed, professionally prepared, and safely preserved. Beside it, Dad's later page looked fragile. Brooke's lawyer argued that the older document deserved more confidence because it had come through a law office. Maya returned to the distinction that had changed the case for me. The question was not which document looked more sophisticated. The later page had to be judged under the rules applying to a will written wholly in Dad's own hand, together with the proof of handwriting, capacity, intent, and discovery. I watched the judge turn the handwritten page. Dad had revoked his prior instructions, left the farmhouse and workshop to me, and directed a neutral sale of the development acreage, so Brooke and I would share the net proceeds equally. He had not erased my sister. He had corrected an old imbalance without creating a new one. The ruling came through findings, dates, and credibility instead of a dramatic speech. Then the later handwritten will was admitted to probate. The earlier will could no longer control the estate where the two documents conflicted. Brooke's path to take the farmhouse, workshop, and acreage under the old plan ended in that room. I had imagined triumph. Instead, I gripped the edge of the table and felt something inside me finally stop bracing. Outside court, Maya reminded me that proving Dad's will did not end every consequence. The neutral administrator's accounting showed costs from the rushed clean-out, storage, attempted developer transaction, and the legal work required to preserve disputed materials. Mason's email mattered here, too. It showed Brooke had specifically ordered the old blue bird guide and loose handwritten papers removed from the public inventory before I told her what Dad's final text said. That became the financial pressure point Brooke could no longer hide behind the old will. Choices she had treated as ordinary estate business now exposed her to reimbursement, surcharge, and further legal fee claims. Her lawyer proposed resolving those issues financially rather than litigating each disputed expense. Brooke would reimburse documented estate losses and certain administration costs, and the remaining misconduct issues would not become another long hearing. I asked Maya what happened if I refused. She said we could seek more, but nothing was guaranteed. Another fight would consume money and months. Then she asked what result I was actually trying to protect. For months, I had answered that question with 2 words: Dad's will. Now I had to prove I meant it even when following it benefited Brooke. The later will gave her half of the net proceeds from the acreage. Part of me wanted to chase every possible penalty until that share disappeared into fees. I remembered the move-out notice sliding across Charles's table hours after Dad's funeral. I remembered the sale stickers, the missing shelf space, and the offer designed to make me surrender before I knew what the blue book contained. But Dad had written Brooke into his final plan. so I agreed to recover the documented losses and legal expenses that belonged back to the estate. I did not ask Maya to turn punishment into a second inheritance strategy. Brooke would bear the consequences attached to her actions, but I would not try to take the share Dad had intentionally left her. That decision cost me more than I expected. Anger had carried me through deadlines and hearings. Letting go of the chance to use the law as a weapon meant accepting that justice was not the same as making Brooke leave with nothing. The next problem was the land. The developer who had pushed for a fast closing had allowed its original offer to expire while probate was pending. Legal and preservation costs had reduced the estate. Delay had cost money, but it had also kept the acreage from being transferred under a will the court ultimately rejected. Dad's handwritten instructions did not give me the right to keep the land simply because I loved it. They required a neutral sale. The administrator marketed the acreage through an open process instead of handing it to the buyer Brooke had been dealing with. I read the reports and asked questions through Maya when I needed to, then forced myself to stop trying to control an outcome Dad had deliberately placed outside either daughter's hands. Eventually, the land sold. After approved expenses and Brooke's required reimbursements, the net proceeds were divided according to Dad's later will. Brooke received her lawful share. I received mine along with the farmhouse and workshop. When the distribution became final, Maya handed me the closing accounting. I traced the lines with my finger and realized there was nothing left to uncover. No missing book, no hidden box, no hearing waiting to decide whether Dad's handwriting counted. The truth had survived long enough to become ordinary paperwork. My relationship with Brooke did not survive with it. There was no dramatic reconciliation. I could not know whether she regretted anything, and I stopped needing to invent an answer. I only knew I could not rebuild trust by pretending none of it happened, and I could not build a future by arranging my life around punishing her. Weeks later, I stood alone in Dad's workshop early in the morning. The acreage beyond the house would eventually change under new ownership. Winning the house had not frozen time. I opened the window Dad used to leave cracked for birdsong. On the shelf beside it sat the old blue birding guide, returned after the evidentiary process ended. The court-certified copy of Dad's handwritten will was stored properly with the estate records. Nothing legal needed to remain hidden beneath the book's loose back lining. I opened the guide anyway. Inside were Dad's faded pencil marks beside bird names, dates from trips I had nearly forgotten, and a childish note in my own handwriting from a morning when I still believed families stayed the same forever. I ran my thumb over the worn edge and understood the mistake I had made for years. I had confused keeping peace with protecting love. Silence had not saved my family. It had only made it easier for the loudest person in the room to define what was true. I placed the blue guide back on the shelf, empty of secrets. The house was mine because Dad chose to leave it to me, not because I managed to take everything from Brooke. Her share was hers because he chose that too. Fairness had never meant getting everything. It meant refusing to let greed rewrite a person's final choice. For the first time since the funeral, I could live with what Dad had actually chosen.